Welcome to Advanced Planning Module 1. Module 1 is on the background to advanced planning, and the learning aims are to discuss what is advanced planning, the purpose of advanced planning, and in the third section, advanced directives and their legal basis. So what is advanced planning? It's important to note the distinction between an advanced decision and an advanced statement. There has been confusion between living wills, advanced directives, advanced decisions, and advanced statements. But advanced decision indicates a distinct refusal of a particular medical treatment or intervention, like do not administer flu vaccination, do not resuscitate in the event of cardiac arrest. Advanced statements, on the other hand, enables a person to make a general statement regarding wishes and care preferences. So just to review, it's important to note that there is a distinction between advanced decision and advanced statement, and this relates to the legal effect of each of those. There has been confusion between the different statements used, but advanced decision indicates a distinct refusal of a particular medical treatment. Advanced statements, on the other hand, enables a person to make a general statement regarding wishes and care preferences. So what is the purpose of advanced planning? It is to say in advance how you would like to be treated if you lose mental capacity, ask for certain treatments or other arrangements. You can say which treatments you do not want. You can get agreement with the main services that care for you. And you could also state who would manage other practical matters should you become ill. So, the purposes are to say in advance how you would like to be treated, which treatments you do not want, to get agreement with the main services that care for you, and you could also state who would manage other practical matters should you become ill. So, advanced directives and their legal basis. Advanced directives, as opposed to advanced statements, are legally binding under common law in Northern Ireland. In England, they're recognised under the Mental Capacity Act 2005 and they're legally binding. In Scotland, they're not legally enforceable under Adults with Incapacity Act 2000. This is an evolving area of law, and if advanced decision is binding, it takes the place of decisions made in your best interest by other people. So what makes an advanced decision legally binding? It's valid if you're over 18 and have the capacity to make, understand, and communicate the decision. You can specify clearly what treatments you wish to refuse. You can explain the circumstances in which you wish to refuse them. The document is signed and witnessed, and you have made the advanced decision of your own accord without any harassment by anyone else. You haven't said or done anything that would contradict the advanced decision. The date you reviewed, and if necessary revised your advanced decision, is accompanied by your signature. And if your advanced decision is about healthcare, it is strongly recommended you discuss this with your GP before drafting it. There are some things that advanced decision cannot do. You cannot refuse treatment at a time when you still have capacity to give or refuse consent. You cannot refuse basic care essentials or the offer of food or drink. You cannot refuse the use of measures solely designed to maintain comfort, like painkillers. You can't demand specific treatment. You cannot refuse treatment for a mental disorder in the event you are detained. And you cannot ask for anything that is against the law, such as euthanasia or assisting you taking your own life. Advanced requests, statements or authorizations have not the same legal status but should be taken into account in assessing best interests, and doctors should still try to follow them. So these are the learning aims of Module 1. What is advanced planning? What the purpose of advanced planning? And advanced directives and their legal basis.